Okay, this is a call to the meeting of December 2nd, 2020 of the Plain Township Board of Zoning Appeals. I'd like to go ahead and introduce our members. Demetrius Poussalides is our vice chairman. Richard Beck is our secretary. Robert Souls, Jeff Sutton, who we've yet to see. Tia Cernova is our alternate. Tia, maintain contact. You may be filling in for Mr. Sutton if we do not see him.
Okay.
And Thomas Ferrara is our zoning director. Attendance roll call vote, please. Mr. Ferrara.
Ms. Cernova,
Here.
Mr. Sutton, Mr. Souls,
Here.
Mr. Beck,
Here.
Mr. Poussalides,
Here.
and Mr. Reichel.
I am present, thank you. Are there any changes to tonight's agenda?
No changes from zoning.
Okay, again, to save time, and the second person, or the second appeal that we're going to be hearing tonight was present. The statement of the duties that we are to uphold are on file and on record in a public office, and they can be found by contacting Mr. Ferrara for the statement of duties. Approval of minutes. We've all received the minutes from our secretary, Mr. Beck. Is there a motion to accept those minutes?
I'll make a motion. Second.
Mr. Souls, okay, roll call vote, please.
Ms. Cernova,
Yes.
Mr. Souls,
Yes.
Mr. Beck,
Yes.
Mr. Poussalides,
Yes.
and Mr. Reichel.
Yes. Moving on, is there any unfinished business?
No unfinished business.
Okay, thank you. New business, we have 3 appeals we are going to be hearing tonight. Appeal number 1320-20 is Power Home Solar. Again, excuse me while I look away. I'm reading this off of our cheat sheet here, so to speak. Appeal number 1321-20, Chad Lovelace. And appeal 1322-20, Rahinder Baal is the appeals. Fire department comments, I'll go ahead and read those into the record. This is addressed to Timothy Reichel, chairman, from Scott Kelly, inspector, dated November 13th, 2020. Subject, review of appeals. Appeal, and I'll shorten this by not reading all of the addresses, but all 3 appeals. Appeal number 1320-20, appeal number 1321-20, appeal number 1322-20. The fire department has no recommendations or suggestions regarding this appeal. Thank you for your consideration, Mr. Scott Kelly, inspector. And again, this can be found with all records associated with this meeting this evening. I'd like to go ahead and administer the oath. Are we going to have to do this individually, Mr. Ferrara, since we don't have a group setting?
I would think so. That'd be up to the board, but I would think we should.
I mean, can everybody else that's going to speak tonight, are they on right now, or do they just come on as when we need them?
They will speak when they want to, and I think Mr. Haynes will allow them in once they flag that they want to say something.
Okay. Well, I'm going to go ahead and administer the oath, and then I'll ask each if they've heard it. If not, I can repeat it. This is for all people speaking this evening. Do you swear or affirm that the information you are about to present is true and accurate to the best of your knowledge and belief? You would answer, yeah, I do. And again, we'll address that. Some other particulars in regards to a virtual meeting. I believe we do have a stenographer / court reporter taking notes this evening. Is that correct?
Linda, are you on?
Merrill. It's Merrill Jonas. Merrill Jonas is on.
Oh, Merrill, okay.
Merrill. Okay. What we request is first, whenever anyone is speaking, please say your name first. Present what you want to say to us. And at all times, only one person speaking. If multiple people start speaking, our reporter cannot pick that up. And so I've been told to tell you that. So with that, we will move on to our first appeal.
Tim, can I interject one thing, please?
Sure, go right ahead.
So any of the participants that are intending to speak, if they could put their name in, I have some users that are going to be difficult for me to determine. So if you would adjust your name so that when you're called, I can unmute you, please.
Hope everybody got that. Well, the first appeal this evening is, let me see, Appeal 1320-20. This is applicant and owner, Power Home Solar, 919 North Main Street, Mooresville, North Carolina, 28117, Eric Johnson, 5421 Linford Avenue, Northeast Canton, Ohio, 44705. Applicant requests a conditional use permit to place an accessory solar system on the roof of the residence at the property located at 5421 Linford Avenue, Northeast Canton, Ohio, 44705. This would be parcel 52-08270. This is addressing section 703.2 B11, conditionally permitted uses. Is there anyone here to speak for the appeal?
Okay, I have a Ryan with the Powerhouse.
That'll probably be him.
I'm going to unmute him.
Go right ahead.
I don't know. Ryan with Power Home should be able to speak if he's on behalf of that.
Yes, I'm here.
Did you take the oath, sir?
I did, yes.
Thank you very much. Go ahead and present your appeal.
Now, I've never done this before. Do you guys have questions for me? Or was
Go
that
ahead and present what you're attempting to do or what you want to do for your client.
Yeah, so Eric Johnson wants to put some solar panels on top of his house to help offset his electric bill. We're looking at, I'd have to double check, but I think it's 21 panels along with a Generac battery that would go in his basement.
Okay. We've seen quite a few of these requests. Is there anyone else to speak for the appeal?
No.
Is there anyone to speak against the appeal?
Well, now, I would need an indication from them in the chat box, or I'd have to unmute the group. Would you like me to unmute the group?
Well, how are we, are they able to raise their hands? Like, I know there's a feature in Zoom sometimes where you can have them raise their hand. Is there a method that we could tell them if you want to speak?
Yes. So in the very bottom, there's a reaction button, which is just right of center. And if they click on that, they should at least be able to do a thumbs up or a clap, and I could unmute them.
Okay.
And the other feature would be, I guess, in the chat, they could say, I would like to speak.
I am monitoring chat right now,
Okay.
Mr. Poussalides, and I'm not seeing anyone, at least in the chat box. In reactions, I'm not seeing any reactions as well. Oh, I've got in the chat box, my name is Barbara Calzola, and I want to speak in support of 1321. That is for the next appeal. So we'll hold on to that one.
I'm assuming you guys know I want to support my own appeal, right?
Yes.
Okay.
Merrill
Yeah.
wants to unmute.
Merrill needs to be unmuted.
She probably wants an address.
You're probably right.
Okay, she should be able to speak.
I don't want an address, but if I need to interject, I need to be able to do so and not be permanently muted.
Correct.
Okay, also, Ryan, can we get your first, last name and your address?
Yeah, it's Ryan, for my first name like Nolan, Ryan. Palmer, just like Arnold. And my home address,
Business address is fine.
7700 Hub Parkway. That's in Valley View, Ohio. Let me grab that zip code real quick. 44125.
Thank you.
Okay, again, I do not see anything in the chat box in regards to any opposition in regards to this appeal. Again, does anyone else want to speak in favor of the appeal for this appeal? Seeing none, hearing none, are there any questions from the board?
I'll just note that the file does have the letter from the utility company that we require under our code, that the AEP sent in. There's a copy of the AEP letter approving of the project. So I just want to note that for the record.
Thank you, Mr. Pusely. I did see that and I failed to mention that. Okay, thank you very much. Okay, may we have a roll call vote on this first appeal, please, or a motion?
Yeah, I'll make a motion. Whereas applicant owner Power Home Solar 919 North Main Street, Mooresville, North Carolina 28117. Eric Johnson 5421 Linford Avenue, Northeast Canton, Ohio 44705 requests the following conditional use permit to place an accessory solar system on the roof of the residence on the property located at 5421 Linford Avenue, Northeast Canton, Ohio 44705. Parcel number 5208270, conditional use permit for an accessory roof-mounted solar system, whereas the applicant or representative has appeared before this board at an adjudication hearing on said application, and the Plain Township Board of Zoning Appeals has duly considered the application pursuant to Ohio Revised Code 519.14, and now therefore it be hereby resolved by the Plain Township Board of Zoning Appeals to grant the following: a conditional use permit for an accessory roof-mounted solar system.
Do I have a second?
Second.
In lieu of any further questions or comments, can we have a roll call vote, please?
Ms. Cernova,
Yes.
Mr. Souls,
Yes.
Mr. Beck,
Yes.
Mr. Pusilides,
Yes.
and Mr. Reichel.
Yes, this appeal is passed. Any additional information can be gathered from Mr. Ferrara at the Plain Township offices. Okay, we'll move on to appeal number 2. Appeal number 2 this evening is appeal number 1321-20. Applicant owner Chad and Melanie Lovelace, 3676 Overhill Drive Northwest, Canton, Ohio 44718, are requesting a variance to build a 5-foot high cable fence in the front yard to enclose the swimming pool installed on the property, which is parcel 52-06089. And this addresses section 602.10 fences, walls, and hedges. Let me note before beginning that in the past week or so that we have received some documents submitted to the office. Some exhibits were admitted by the Lovelace family. Also, 2 letters we received, one in favor, which would have been Lieutenant Ryan Carver of the Sheriff's Department, Stark County Sheriff's Department, and one in opposition, which is the Park family, I guess, wintering in Dade City, Florida. I will not read those letters into this report this evening, but they will be on file with all of the other documentation attached to this appeal. So with that, is there anyone to speak in favor of this appeal?
To present the appeal, Tim.
Yeah, to present the appeal, excuse me.
Well, I'm going to have to unmute. Stand by. Stand by.
And just not to interrupt, but Jeff Sutton has made an appearance, and his name is Susan, which would be his wife, but someone's going to need to unmute him.
Okay, he should be able to speak now.
Hey, Jeff.
Yeah, I've been here, but this is my wife's computer.
Okay, so I need to unmute the participant that is going to be in favor.
The one presenting the appeal, which what I would imagine would be Mr. and Mrs. Lovelace.
Stand by. They are unmuted.
Can you hear us?
Yours now?
Yes.
Okay.
Hello, how are you guys?
Hi. So I just wanted to check first that everyone has had a chance to review the pictures that we submitted and go over the timeline, all the board members.
Yes.
Everybody was able to view those, okay. So we were here to discuss the fencing proposal, and we don't want to change the direction of the meeting. However, we feel that it's imperative to first address some slanderous and errant statements that were made about our project, our family, and our character in our absence at the previous meeting. So we're going to try to quickly do this and then get to the real reason we're here, which is for our fencing. Mr. Sadhu, who is the neighbor across the street from us, claimed that due to our landscaping, the road is now dangerous because there's nowhere to duck off the road and someone is going to get hit. He stated that he lives across the street. To clarify, he lives on Apple Grove, not across the street. His elderly father lives there. The event he noted about a family walking with a carriage at 7:30 p.m. in the first week of October couldn't have been accurate. It would have been dark at that time. Our landscaping did not change the width of the road, and he failed to mention that the yard across the street from our property that he apparently owns has a berm which also prevents pedestrians from ducking off. Rather than touting lies that we have encroached on the road, he should petition the local police to patrol for speeders, and he himself should stop to allow cars to pass where the road narrows and slow down as everyone else does to allow for safety of pedestrians and carriages. Mr. Baker, who is our neighbor to the right, claimed that there is nothing but a 10 to 12 foot high berm of rock, and there is nothing nice unless you're inside the hole, the pit, the pond. It brings to question how Mr. Baker would know this unless he had trespassed onto our property, which we have evidence of. Additionally, he failed to mention the flora planted in mulch beds aligning the rock beds, as well as 120 arborvitae trees we planted as part of the natural pull project. Mr. Baker also stated that we're only requesting the fence for insurance purposes, and we would be 20 feet off the back of his house if we were putting our fencing in. Let it be clear that the liability for safety of trespassers for insurance purposes is not our only reason. We have invested our hard-earned money and time into this property and have every right to want to protect our investment and family. This brings to the forefront the biggest challenge we are facing: constant trespassing by pedestrians, neighbors, and cars. Fencing limited solely to the natural swimming pool area would not suffice, as trespassers take liberties to access our property from all sides, including our driveway. You can see the multiple images of trespassers within the pictures we provided to the board for review. However, this is just a few of the instances that we were able to capture. Note that in the instance of the white truck trespasser, the police were called and nothing was able to be done. We were told by the policeman, who was very nice, that he would be unable to tell us who the trespasser was. This is the gentleman that walked around the entire length of our property and our children were home alone. Regarding the new cable fencing being off the back of Mr. Baker's house by 20 feet, we have a privacy fence on that side of our property which already aligns the back of his house. This new fencing would be further off the house than that which is currently in place. Note that multiple aggressive verbal interactions with Mr. and Mrs. Baker, as noted on our timeline, as well as their complaint that when we pull into our driveway, our headlights shine into their house, contributed to our decision to place the privacy fencing on our property several years ago. This decision was further confirmed by Mrs. Baker's most recent actions in passing our property and sticking her middle finger up at Chad twice. Mr. Baker said, "I don't find anything to be looking good. The only place he has put in all this fancy stuff he talks about is on top of his place." Mr. Baker is entitled to his opinion, but the idea that he doesn't approve of our style of landscaping is hardly a fair argument against fencing. By comparison, we could argue that his Christmas red paint on his home, his mulch pile covered with a tarp for 4 months, his yard debris that sat and rotted for an entire season, his dead tree stump in the front of his yard that he puts plants around, and his lawn decorations are unsightly, but it is his property, and he is entitled to do what he wants with it. His standard for property care is only valid for his property. His taste in landscaping does not stand as a logical basis for denial to fencing, and it is an illogical argument. Mrs. Steinbach stated that when they first moved in, we were clearing the trees and they didn't understand the scope of our project. We do not owe anyone an explanation on anything that we do within our legal rights as property owners. However, as Mrs. Steinbach felt it was necessary to make assertions and speak falsehoods, we will offer this. The trees were removed because they were unhealthy, diseased, dead, and rotting. They had begun to fall during storms. There was overgrown brush intermingled with yard waste and trash thrown in from neighboring properties. We felt the best course of action was to remove the dead trees. Mark, the owner of Haymaker Tree Services, and Rich Affolter did the tree work removal for us. They were willing to be contacted to verify our account of the neighbor who blocked our drive, called the police, and proceeded to verbally attack them while moving her car back and forth to prevent Chad from leaving our driveway. At this time, when our trees were removed, there was no swimming pool planned. Mrs. Steinbach falsely stated that as fact. Mrs. Steinbach also stated that we share an easement for utility access to power lines, which is now compromised by our pool, and that we have encroached upon the utility access. To clear up her egregious statement, and as documented by the picture of the section of our adjoining properties previous to the swimming pool that was included on the board that we provided, trucks were never able to access power lines through this section. Additionally, prior to our removal of the dead trees in conjunction with the flooding of that same area, they were never able to access it through our yard either. There is now a pathway which is accessible for workers to walk if they need arises, and they can access it now from Overhill Drive, whereas before the lines could only be accessed from the back neighboring properties. Mrs. Steinbach's assertion that we have encroached upon the easement is false and inflammatory. She is clearly unaware, much in the way that Mr. Saduk was, that in asserting we encroached on the road, that encroachment means to enter by gradual steps or stealth into another person's possessions or rights. We've not encroached on anyone's possessions. Our project and landscaping is within the survey lines that we hired the survey company R.M. Warner to mark. Mrs. Steinbach is also unaware of the term easement, which is the right to cross someone's land for a specified purpose, as in the way a utility company walks across your yard to read a meter or work on a line. The utility company does not own the property. The easement is a section of property, in our case, ours and the Steinbachs, which the power company may someday use to work on lines. We cannot encroach upon our own property. Mrs. Steinbach stated that she was at the meeting to learn more about the project, as they had missed it in the beginning when Chad was filing for permits, and that the project has not been completed as Chad stated. She missed the purpose of the meeting regarding fencing, that the swimming pool had already been approved and finished. It is interesting to note that Chad had previously spoken to Mrs. Steinbach about the project out of courtesy on 2 occasions to let them know what we were planning. Her opinion that the project hasn't been completed as Chad stated is just that, an opinion. When Chad was on the side of our property adjoining theirs, Mrs. Steinbach refused to acknowledge Chad when he said good morning, and both she and Mr. Steinbach avoid us when they happen to cross paths. She has no knowledge of the project or timeline. As a point of reference, our project was completed within the year as planned and indicated on the permit, which was issued August 19, 2019. Keep in mind that we finished the project on schedule during a pandemic shutdown when supplies and equipment were unavailable and crews were unable to leave their homes or go to work. Mrs. Steinbach slanderously stated that we had underage workers
Mr. Chairman,
at the construction site.
Ms. Lovelace, I'm going to interrupt. As on behalf of the board, at least I'd indicate that the purpose of your appeal is specifically related to the fence.
Mhm.
So I think we've heard a little bit enough about, at least I have, concerning
The
all
history.
these issues. So I would ask that the appeal be addressed specifically regarding the fence, because that's what we're here for this evening, and that's what I anticipate hearing more about from you and from anyone else who wants to speak. But I think I've heard enough about all the other issues that you have with your neighbors, which don't.
However, these were not just issues we have with our neighbor, but they were slanderous things that were said that were untrue. And that was the board's basis for the first denial. So I just want to make sure that our bases are covered and the board is fully aware of the egregious things they said, because that was what you initially, if you were the same people that agreed to deny it, based it off of. So I just want to make sure that's covered.
Well, and I'll state that's not why it was denied.
It was denied because it wasn't presented.
Exactly. Thank you.
If you want to go ahead and state the basis for.
I would like to continue with something that is relevant to the fencing, please.
Yeah,
Mrs.
if you want to go with that. For the
That a dog or a future child she would have would climb in and fall and drown in our pool, and she knows the cable fencing would not protect against that. The one thing that we agree with her on is that children and dogs could trespass and fall and drown into our pool. Based on this, she stated that the cable fencing is not code, and she doesn't obviously understand construction because the cable fencing is 3 inches apart and it is code. And to touch on the fencing with what the appeal was in the beginning, he stated we were asking for 5 foot. The renewed appeal, we had to change it in order for this redress meeting, and it was changed to 4.5 feet. So I think that maybe that the board just happened to miss that. I know there was a lot of paperwork, but we did change it to 4.5 feet, not 5. So I just wanted to touch base on that. But I would like to add that Mrs. Steinbeck, on 2 occasions, 2 of her own guests, one at a dinner party and one when they were trick-or-treating, trespassed on our property. One ran up through our mulch when we had.
Ms. Lovelace, again, as Mr. Soul stated earlier, this is not a court of law in terms of determining slanderous statements or behaviors from your neighbors or lack thereof. This is strictly here to present your appeal for a fence that you want constructed on your property. Let's stick to that right now. Forget Mrs. Steinbach and everybody else, and let's present the appeal for the fence, please. We get where you're coming from.
Thank you.
So we've been intentional about following the guidelines for the project, which is the reason for the permit filing and the fencing appeal. And the fact is, we need adequate fencing. 3 feet is not going to do anything to deter people and vehicles from trespassing. They're trespassing from all corners of the property. They're driving up our driveway all hours of the night. We had a vehicle stolen out of our driveway September 2nd, 2019, 2 vehicles broken into. We've called the police, and even though they're nice, nothing's been done, so we're unable to press charges. We have sheriffs driving by, taking pictures that are part of Avondale, and completely inappropriate behavior. And my family should not be subjected to this kind of behavior. Not only is the pool an issue because of the depth, and there are guidelines for that we should follow for safety of people and for our own protection, but we also need protection on our property. We've had to put up no trespassing signs because so many people continue to violate that and trespass.
Thank you. I appreciate that.
Now, in regards to the fencing, I know that we've changed the appeal for the way we want the fencing to look. We really did prefer to have the stone columns at 4.5 feet. We really wanted them at 5 feet. That was our original intention with gas lighting. We thought that would look very beautiful. But since we had to change that, we would prefer to have the 4.5 foot stone columns with lighting and the 3-inch cable, which is code, across the entire unfenced portion of our property. If you're unable to approve the stone columns, we're willing to compromise and do white posts with solar lighting, but we really prefer the 3-inch cable still. And again, on the unfenced portion of the property. We just don't feel like anything under that's really going to deter people from trespassing.
Thank you.
You're welcome.
Is there, I see in the chat box that there is a Barbara Calzola that wants to speak in favor of this appeal. Is there any one way to unmute her?
Stand by. Okay, she can speak.
Hi, my name's Barbara Calzola, and I live.
Barbara,
Hi.
Barbara, first, yeah, did you hear the oath that I gave at the beginning?
I did.
And could you state your name and your address, please?
Yes, I will.
For our
It's
report.
Barbara Calzola, and that's spelled C-A-L-Z like in zebra, O-L-A. And my address is 3310 Fulton Drive, Northwest. And I also live in Avondale.
Thank you. Go ahead and present your remarks to the board, please. And I have a frozen Mrs. Kelly. There she's unfrozen.
Okay. So I also live in Avondale, so it's 44718 in Canton. I just want to say I've lived in Avondale for 23 and a half years. And I know regarding the fencing and everything like that, what the Lovelaces have done to this property, because we walk that area all the time. We're on the other side of Avondale, but we walk that area. We walk with our granddaughter. We've walked with our kids over the years and our dogs and everything. And that property is beautiful now that they've taken out the trees that were there and they've put in this natural pool. And I understand their concern for wanting to make sure that people are not accessing their property and having it fully fenced, because there is a safety issue. They have 5 children that are home with them that they homeschool. And I only met them through work, work, because I'm a realtor, and I met them through work, but now we've become friends as well because they're very good people and they've done a lot for our neighborhood with the improvements they've done on the home. And I only think that the fence that they are proposing to put up would add to the value and the look of their home, not deter from anything that anybody else is. I mean, I listened to the meeting prior that was presented, the presentations from their neighbors and stuff, and that property was very, very derelict, run down. The neighbors on all sides were using it as a dump base, so they've cleaned all that up and it looks nice, and the fence would be to their benefit to keep them protected. And I can say, as a resident of Avondale myself, and having a circular drive in the front, that people do just tend to drive into your driveways and use it as a turnaround or go and look and see what they want. We've had people walk in our backyard. We don't have a fence around our yard, but if I had a pool, I definitely have a fence. And the height of the fence is kind of confusing to me. I understand that they weren't at the last meeting, so and I heard from the last meeting because I watched it that they were complaining about the height of the fence and all these other things. We have a neighbor 2 doors down from us in Avondale who they're at 3210. They have a wooden stockade fence around their property, which the association allowed. We did say, hey, and they have an above ground pool, which is also against association. I don't think the Avondale Association should have any say so whatsoever in what anybody in our association does with their personal property, actually, because they're very subjective in how they enforce it. And I've been a resident here for 23 and a half years, and I have 2 neighbors that have privacy fences, which supposedly are not allowed in Avondale, and above ground pools, which are supposedly not allowed. So I have issue with anybody from, including Alan Harold, coming there and saying anything about people not following the rules, because they don't enforce the rules across the board. This fence that I've talked to Chad and Melanie about the fence and what they want to do and how they want the posts and everything. It's going to be beautiful. I don't know if any of you have driven by their property to see what they've done, but it is a beautiful project, and they have every right to protect their property from people who want to come on to their personal private property and look at it or take pictures of it or whatever. I mean, they're very nice people. If you wanted to ask them about it, they'd be more than happy to show you it. That's the kind of people they are. So they've been a benefit to our neighborhood, not a detriment. And what they are trying to do to their property is a benefit, not a detriment. I don't see any reason to deny them putting this type of fencing up and with the lighting and things that they've proposed.
Thank you very much. I
Mhm.
appreciate your comments and the board appreciates them.
Thank you.
Is there anyone else to speak in favor of this appeal?
I have Adam Farley chatting that he'd like to speak in favor. I'm going to unmute him.
Please.
Mr.
Hello.
Farley.
Yes,
Mr. Farley, first, did you hear the oath that I gave earlier?
I did hear the oath.
Thank you very much. Would you please state and you accept that oath, correct?
I do.
Will you please state your name and your address, please?
My name is Adam W. Farley. I live at 3665 Overhill Drive Northwest. I'm directly across the street from Chad and Melanie.
Okay, sir, go ahead and present your comments, remarks to the board.
First, I'd like to just say that, the case that Melanie laid out, I believe it was valid and it had a lot of merit after watching the previous meeting where all the neighbors were allowed to talk about all the things they didn't like that have already been done that had nothing to do with the fence. So I just think it would be fair to bring that up. But additionally, I think that it makes perfect sense for there to be a fence around that. I have a pool in my yard. I'm required to have a fence around it. And I think there should be a fence around that, not only for my kids, but any kids in the neighborhood and in the future that may not even live here yet. The Stark County soil engineer thought it would be a good idea to put a retention basin there after Chad had them out to the property. And what Chad has done at the property is much better than what the county would do with a retention basin. So I'm completely in support of that. But to the main point, the fence, I think it should be there, and I don't think it will negatively affect my property value or anyone else's. And I just want it to be known that I think it's a good idea and I'd like it to go through.
Thank you, Mr. Farley. I see in the comment or the chat box that Lisa Campbell from Plain Township would like to speak to everyone.
Okay.
Thank you.
Stand by.
Thank you, Mr. Farley. Can we unmute?
Yes. Eric doesn't like to unmute me, but I am unmuted.
Okay. You
I
wanted
did
to
hear
say
the
something?
oath. Yeah, I did hear the oath. I took it. Typically, I don't get involved in zoning hearings. However, this has become somewhat of a township issue now and an issue with our sheriff's office, as there has been some pretty significant trespassing. And once it involves our sheriff's office, that involves resources of the township. And it is, a resource that we don't like to spend when it's a neighbor trespassing on another's neighbor's property. And this is a case where I'm in favor as the township administrator of that size of the fence going around the property. Anything to eliminate the trespassing and save our resources in the township on more important issues, we're in favor of. Speaking as the administrator, I know Ryan Carver's on the line. He wrote a letter in support for the exact same reason. Once it starts to involve the sheriff's office, it's a township issue. I would ask, I did watch the previous meeting. I do feel like those neighbors had free reign to slander the Lovelaces. The other concern I had, I know that the homeowners association has a stake in this, but to be fair, that's not an issue for the board to consider as the homeowners association. So I'm just asking that that same courtesy or request you made of the Lovelaces be made to the HOA representative. But speaking as the township administrator, given the extenuating circumstances and the egregious trespassing, I am in favor of that fence.
Thank you, Ms. Campbell. Do you know if Lieutenant Carver was going to speak this evening, other than the letter that he submitted?
I think he was just here if anybody had questions about the letter. He gave Mr. Harold some further follow-up on why he felt the way he did about supporting the fence. So he's on the line unless he hops on to speak or people have questions about the letter. I think the letter speaks for itself.
And that record, again, is kept with the other documents
Yes.
pertaining to this appeal, and is open to public view for anyone that wants to come to the office to look at that letter. I see somebody wants to speak against, but I'm not there yet. Is there anyone else to speak in favor of this appeal? And I'm not seeing anyone in chat. Again, I'll go.
I'd like to speak in favor.
And who are you, sir?
My name's Isabella Lovelace. What? Oh, can you hear me?
Yes.
Sorry.
Did you hear the oath earlier?
I did, yes.
Okay. Could you state your name and your address, please?
My name's Isabella Lovelace. I live at 3676 Overhill Drive, Northwest Canton. I have witnessed on several occasions people trespassing and walking onto the property. And on another one, I think my mom and dad touched on, was somebody pulled their car halfway up our driveway and then parked there for a minute and was staring at our property. We have had people come past our property, take pictures. Once my family was swimming, I was not out there, but somebody in a truck parked on the hill, stood on top of his truck through the sunroof and took pictures. And mind you, everybody was in swimming suits, so that's kind of creepy. And I was also one of the supposedly underage workers that was working outside on different occasions. And while I was working, I cannot tell you how many people stopped me to ask questions or walked on the property. It was insane. Like, there were so many people that came onto the property and were stopping me to ask questions. So it is definitely a problem that we need a fence for it. And then also my little sisters who are outside can't be outside without supervision because so many people are coming onto the property.
Thank you for your comments.
Thank you.
Is there anyone else to speak for the appeal or in
Yes,
favor of the appeal?
Yes, I would like to speak.
And sir, did you hear the oath?
Yes, I did.
And you abide by that oath?
Yes, I do.
And please state your name and your address, please.
Jim Chundry, 3420 Brook Park Street Northwest, Canton, Ohio, 44718.
Please, sir, direct your comments to our board, please.
Well, I'm just in favor of the fence. I think anyone who has a pool should be entitled to put a fence in their area. I know that he has increased the property value of that whole neighborhood. And it's a shame that he has to be harassed by the people in Avondale. You know, they haven't lived here that long and they have a family. And with all the things that are going on in this world, the last thing we need is somebody that's bettering our community to be harassed. And I think this fence would be nothing but a benefit for him and his family and increase everyone's property value. So it's to me, it's a no-brainer.
Okay, sir. Thank you. Thank you for your comments. Again, anyone to speak in favor or for this appeal?
Mr. Chairman, I did allow anyone to unmute themselves, and I can unmute the entire group. My guess would be the rest will be against. So if you'd like, I can unmute, but we'll still need to stick to one at a time.
Well, yeah, and I see at least one name in the comment section for against. So let's go with Anthony Girolamo. Excuse me for butchering that. It says here in the chat box you want to speak against. Is he unmuted, please?
I should be. Can you hear me?
Yes, we can hear you, sir. Did you hear the oath?
I did.
And you abide by that oath?
I will.
Well, please state your name and your address, please.
Yeah, my name's Anthony J. DiGirolamo. My address is 2936 Westmoreland Avenue Northwest, Canton, Ohio. I'm an Avondale resident, and I'm here on behalf of the Avondale Community Improvement Association. And I don't want to belabor this. I don't want to take up a lot of the board's time unnecessarily, but just a couple of the comments about the board or the Community Improvement Association enforcing its rules. We do make decisions on fences and other things on an ad hoc basis. We in fact approve the white privacy fence that the Lovelaces have installed. So we do consider the property, the lay of the land, design, etc. when making fence decisions. The references to above ground pools that are allowed, there are many that are grandfathered in. So I'm sure that that resident doesn't know which are grandfathered in and which aren't. The fact of the matter is the Community Improvement Association intends to enforce the deed restrictions which are made available to every single resident when they purchase their property. We intend to enforce all of our deed restrictions regarding fences and other things like operating a business in the neighborhood of Avondale. The reason I'm here today or tonight is simply to advise the zoning board that the Lovelaces have never made an application for approval of this fence with the board. And I know that that's not a condition of your approval, but I want to make your board aware of that. And to ask the Lovelaces, if this fence is approved, when will the Avondale Community Improvement Association see an application?
Thank you. Is there anyone else to speak against the appeal? Please make yourself known. We do have the one letter from the Park family that's been put into evidence via a letter. They cannot speak. Obviously, they're in Dade City, Florida, according to the address that they gave this board. So with that, not hearing any more against the appeal, are there questions for the board members, please? Questions from the board?
I'll just make an observation. I have driven by the property. The property does look very good. You know, a lot of this is like a neighborhood dispute or neighbors having a dispute, which is, you know, we're not the trustees. We really don't deal with that. And I think we talked about that a little bit at our last meeting. You know, we look at the zoning code, and the last meeting we had, I know we made a decision based on the facts that were presented to us. Not opinions, but facts, compared to what our zoning code requires. So, you know, I know there's some hard feelings, and we had like a little bit of a cathartic experience here of everybody in the last meeting and this meeting, but it's just so that everybody knows this board, you know, we function not based on that, but based on what our zoning code says, and we make a decision based on that. So personally, based on what I've seen this time around, I mean, the most important thing is the fire department, the road department, the sheriff department, and our administrator came in to talk and testify today about the importance of having this fence here. So I'd be in favor of this fence based on that, not based on all the other stuff. And I think Mr. Souls pointed out at the last meeting, and correct me if I'm wrong, Bob, the homeowner association, it has no bearing on what we do. Please tell me if I'm wrong.
No, that is correct. That's what I indicated. Obviously, they can speak and indicate their disfavor relative to the fence, or applications need to be made, but ultimately, from our standpoint, any application of any association rules don't apply to the Board of Zoning Appeals. That would be a separate legal matter between the association and the homeowners. Our particular purpose is to determine whether or not we should grant a variance to the fence, and in this case, 1.5 feet over the 3 foot, which is what are permitted for the front yard.
Any other
So with-
questions?
I don't. I'd like to make a motion though.
Go ahead, Mr. Souls.
Applicant and owner Chad and Melanie Lovelace, 3676 Overhill Drive, Northwest Canton, Ohio, 44718. Request the following height variance to construct a 4.5-foot high cable fence in the front yard of their residence, when the zoning resolution calls for the maximum height of a fence in the front yard of a property to be 3 feet high. So they're looking for a 1.5-foot height variance required, 3 foot permitted, 4.5 feet requested. Whereas the applicant or a representative has appeared before the board at an adjudication hearing on the application, and the Plain Township Board of Zoning Appeals has duly considered the application pursuant to Ohio Revised Code 519.14, and now therefore be it hereby resolved by the Plain Township Board of Zoning Appeals to grant the following: a 1.5-foot fence height variance, 3 feet permitted, 4.5 feet requested.
I will second that.
And, you know, from my standpoint, I would be in favor of granting this variance. The primary consideration from my standpoint is this is a unique property with the fact that it has this pool or whatever is considered back there, I guess, this pool. And obviously safety is of concern. And I think a higher fence would be more beneficial for the protection of, you know, those around the neighborhood or anyone approaching from that standpoint. So from my standpoint, that would be my primary consideration for granting a variance as it specifically relates to this property.
Thank you, Mr. Souls. Any other comments or questions from the board?
Just one clarification.
Thank you, Mr. Beck.
Did you second or was it Demetrius?
I did, sir.
Okay.
I think I beat Demetrius 2 at this time. He always beats me out every other time, so.
Mr. Chairman, can I interject?
Yes.
I would recommend that I unmute just to make sure that everybody has an opportunity if they are in opposition, that we do have several that I have not heard from.
Well, we've already closed that.
We've closed that now. Motion has been made and seconded. I asked twice if anybody else wanted to speak against, and I got no response via chat or verbally. So this, it's been closed. Motion has been made. It has been seconded, and it's time to move on and ask for a roll call vote, please.
Ms. Cernova.
Yes,
wait,
if I can still
wait.
on.
Yes, a method of procedure. When
Yes.
she cast her first vote for the first appeal, Mr. Sutton was not present. Mr. Sutton is now present. Mr. Sutton heard the second appeal.
Thank you.
So I believe the vote, and Mr. Souls or Mr. Pusalides, if you can correct me, the vote now goes to Mr. Sutton because he was in attendance at the reading of the appeal and in listening to all factors regarding the appeal.
Yes.
Is that correct?
Yes.
Thank you.
Very good. Mr. Sutton.
Yes.
Mr. Souls.
Yes.
Mr. Beck.
Yes.
Mr. Pusalides.
Yes.
And Mr. Reichel.
Yes. Based upon both comments made by Mr. Pusalides and Mr. Souls, I tend to be in agreement with theirs. So yes, this has passed. Again, if you have any questions, you can direct those to Mr. Ferrara at the Plain Township Zoning Department.
There is a question, Mr. Chairman, from the
Yeah.
applicant on the chat.
Okay.
I do not believe our motion addressed.
It did not address either one of those questions.
Personally, I would think that 4.5 feet is the height of the fence, no matter what it is. So that would be my interpretation.
Right, so it could be stone or white post, correct?
Yes.
Thank you for bringing that to our attention, Mr. Beck. I missed that in the chat box. Okay, let's move on to our last appeal of the evening. This is appeal number 1322-20. Applicant and owner, Rahinder Bao, 4871 Nobles Pond Drive, Northwest Canton, Ohio, 44718. Applicant requests the following setback variance to construct a 25-foot by 43-foot, 1,075 square foot addition to the retail plaza located at 3974 Fulton Drive, Northwest Canton, Ohio, 44718. Regarding parcel 52-19624. This addresses the Article 7 addresses section 713.3 and section 713.4, minimum lot and yard requirements. Is there anyone here to speak for the appeal? Or present the appeal, excuse me, Mr. Souls. You always correct me on that. I say speak for, but somebody to present.
I believe, is it Raj who's here? He's still muted. Would that be the applicant, I'm assuming?
That is applicant owner, Raj. Can we unmute Mr.
There we go.
Yeah, you hear me?
Yes.
Yes.
Yes. Yes, sir.
Sir, did you hear the oath that I read earlier?
Yes, sir.
Do you abide by that oath?
Yes, sir.
Raj, will you please state your name and your address, please, and then present your appeal?
My name is Rajinder Kebao, and address is 4871 Nobles Pond Drive, Kenton, Ohio, 44718.
Thank you, sir. Go ahead and present your appeal.
We're appealing, there is a variance in 25 feet, and we're looking for 15 feet. So we're looking for 10 feet variance.
And the reason being?
We're going to making a plaza little bit more bigger backside, meaning building a attached little bit additional.
Are you going to be remodeling? Well, I won't ask any questions yet. Anyone else want to speak for the appeal? Is there anyone to speak against the appeal? Now, we can ask questions from the board. Does the board have questions? I guess my question was, is this a total remodel job, or you're just adding more space, or both?
Remodeling and adding a little bit of space more.
Okay, do you have somebody for that space?
Yes, sir.
You do, okay.
Yeah. He's my tenant, and he doing some sign business. So he want a little bit more space. So he make a showroom.
Okay.
Yes, sir.
And again, Mr. Go ahead.
I was going to say, how come you can't make it 10 feet smaller than what you are to meet the variance requirements?
Then the whatever space he need, that's not enough. Then he has to move out somewhere.
Okay.
Because he needs showroom, and plus his his shop, beer shop. So he fixes the machines.
Okay.
And you're stating that if he does not get that space, he's indicated to you that he would move on?
Yes, because he need a little bit more space. Otherwise, he go find somewhere other space.
And that would be a financial setback to you?
Yes, sir.
Thank you. No further questions. Any further questions from the board? Not hearing any. Do I have a motion?
Make a motion, whereas applicant owner Rajinder Bao, 4871 Nobles Pond Drive, Northwest Canton, Ohio, 44718, requests the following setback variance to construct a 25-foot by 43-foot, 1,075 square foot building addition to the retail plaza building located at 3974 Fulton Drive, Northwest Canton, Ohio, 44718, parcel number 5219624. 10 feet side yard variance required, 20 feet permitted, 15 feet requested. Whereas the applicant or a representative has appeared before this board at an adjudication hearing on said application, and the Plain Township Board of Zoning Appeals has duly considered the application pursuant to Ohio Revised Code 519.14, and now therefore be it hereby resolved by the Plain Township Board of Zoning Appeals to grant the following: a 10-foot side yard variance required, 20 feet, 5 feet permitted, 15 feet requested.
Second.
That was Mr. Beck.
Yes.
Thank you. Can we have a roll call vote, please?
Mr. Sutton,
Yes.
Mr. Souls,
Yes.
Mr. Beck,
Yes.
Mr. Pusilides,
Yes.
and Mr. Reichel.
Yes. Raj, your appeal has been granted. If you have any further questions, please contact our zoning department office at Plain Township.
Thank you so much, sir. I really appreciate for you do that.
Thank you, sir.
Thank you.
Any announcements? I guess I'll make one.
Oh,
It looks like we don't have any meetings for January.
Thank you. It was made apparent to me by Mr. Ferrara that my business was coming to an end at the end of the month of December. And I was to submit a letter stating whether or not I wanted to remain on the board or leave the board. And I said, with the trustees and of course with you, my friends, if I am worthy, I will stay on for another term. And I indicated that to Mr. Ferrara, who has to present that to the trustees. So if you approve of that, I guess it's the trustees that will approve that, but you're stuck with me again, possibly. That's the only announcement I had to make. Do I have a motion to adjourn?
so moved.
Second.
Who seconded that? I'm sorry.
I did.
Demetrius.
Okay.
And roll call.
Mr. Sutton,
Yes.
Mr. Souls,
Yes.
Mr. Beck,
Yes.
Mr. Pusilides,
Yes.
Mr. Reichel.
Yes.